This is an important topic, one that I've focused a lot on for the entirety of the 15 years I've served in the Senate and on the Senate Judiciary Committee. Each time we bring up this issue or another issue related to it, we tend to hear a very similar set of arguments. The arguments go something like this. Yes, there have been problems in the past. Yes, there have been abuses of FISA 702. But you need not worry because we now have procedures in place, administrative procedures that will fix the problem once and for all. We now have to have even more layers of administrative approval within the agencies charged with administering this framework, and so you need not worry. What you ought to be worried about is another 9/11. What you ought to be worried about is that we are all going to die unless the U.S. government has the ability to collect content of private communications involving U.S. citizens without a warrant. I find this rather troubling because that's not what the Constitution sets up. The founders didn't design a system in which liberty and the protection thereof depends on compliance with manuals. Now, in Riley versus California, Chief Justice Roberts, writing for a unanimous court, explained that while it's probably a good idea, as he put it, for the government to develop search and seizure protocols, quote, the founders did not fight a revolution to gain the right to government agency protocols. Ms. Goitein, I'd like to start with you. Do you agree that without a probable cause warrant, a probable cause requirement, with a warrant being issued by a co-equal branch of government, 702 lacks the structural checks and balances that are necessary and that the Founding Fathers deemed necessary in order to restrain executive power in this area?
I would agree with that. I would agree as a legal matter and a practical matter. As a legal matter, as I was starting to say, the Supreme Court has held that the Fourth Amendment applies not when there's been an intrusion on property, but when there's been an intrusion on a reasonable expectation of privacy. And Americans have a reasonable expectation of privacy in their communications with others, including foreigners. If these Americans voluntarily gave their communications to the government, they would waive that interest. That's the third-party doctrine. That's not what has happened here. And there have been cases in which the government obtained information and returned the actual property, the laptop, to the person who owned it, mirrored the contents, kept those contents on its own property, its own hard drives, its own disks. And the court in the Second Circuit in Ganias still held that the Fourth Amendment limited the government's ability to keep and access that data.
Yeah, that is a great point. And if we look back the history of the Fourth Amendment and to the centuries of English antecedents to the Fourth Amendment, preceding the Fourth Amendment's adoption, what we find is not a situation in which it was adequate that those who were executing, I don't know, writs of assistance or general warrants under English law, those administrative layers of approval and compliance manuals that I'm sure they had, didn't do the job either. And that's why we have a warrant requirement. That's why it's so important. Now, Mr. Baker, in your written testimony, you make an analogy to driver's licenses and to the ability to search DMV databases for driver's licenses. I'm not sure that one helps you much, though. I'm not sure that helps the argument here. I mean, first of all, you're dealing there with information that is lawfully obtained by state governments on American citizens. They become sort of matters of public record that somebody has a driver's license. Whereas with FISA 702, you're dealing with the contents of private conversations and private conversations directed at foreign intelligence. So isn't that the first point where your analogy breaks down?
No, I don't think so. The purpose of 702 is to collect the communications using U.S. infrastructure of foreign targets. Of course, some of those foreign targets are going to be talking to Americans from time to time, and you can't collect their communications without also getting the Americans who are talking to them. But you have lawful authority to gather those communications. And once gathered, you can use them for other purposes that are related to that. And
Well, sure. But if you get in there, I mean, it becomes analogous at some point to an officer who figures out a way to get inside of a home and then exploits that, or figures out a way to initiate a Terry stop and then extends that visit longer than it was intended to cover at the outset. One more point before my time expires. Mr. Klein, a moment ago you made some references to 9/11 and to the fact that, lamenting what happened then. Now, last I checked, 9/11 was carried out entirely by foreign nationals, not by American citizens. How does that justify warrantless surveillance of private communications involving U.S. persons on U.S. soil?
Well, U.S. persons also includes lawful permanent residents, so under the statute, that term
Fair
includes
enough.
lawful.
Fair
so
enough.
there are
These
many,
were not LPRs, but regardless, go ahead.
Sure, and it's possible that Americans are sometimes, unfortunately, suborned, recruited by foreign terrorist groups as well, sometimes unwittingly, are used by foreign terrorist organizations. In those cases, a U.S. person query can help warn that person, redirect them away from being recruited. In fact, a significant proportion of the queries that are run are actually relate to victims of things like cyber attacks or unwitting recruitment by foreign intelligence services.
But that is not what those of us who are concerned about 702 worry about. That is not our principal focus. Our focus is when somebody is going after information, private communications of U.S. persons, there ought to be a warrant requirement.